And now let's turn it over to our next panel. This is going to be exciting as well with Professor Shannon and Judge Turner. Texas Mental Health Law, what you need to know. Professor Brian Shannon is a Paul W. Horn professor at the Texas Tech University School of Law. He serves as a fellow commissioner on the Texas Judicial Commission on Mental Health and is the author and co-author of many articles and books, including 6 editions, that's right, 6 editions of Texas Criminal Procedure and The Offender with Mental Illness, an Analysis and Guide. Judge Ryan Kellus Turner has more than 2 decades of experience working in Texas courts, judicial education, criminal justice, and government. He has been licensed to practice law since 1998. He obtained his Juris Doctorate from Southern Methodist University and his bachelor's degree in psychology with the highest honors from St. Edward's University in Austin, Texas, where he has served as an adjunct faculty member in the School of Behavioral and Social Sciences. So I'll turn it over to you, Professor Shannon.
Thank you very much, Dr. Martinez. It's great to be with everyone this morning and getting to co-present with Judge Turner. I guess I ought to issue a disclaimer before we get too far in this. One of the courses I've taught for many years is contracts, and I'm a little nervous about our title, Texas Mental Health Law, What You Need to Know, and that we've got 45 minutes. So we're not intending any kind of warranty from that. Obviously, we're going to dip our toe in the water and try and identify several hot issues that we think would be helpful for everyone to have a good understanding of. And so we're going to trade off. I'll address the first several slides and do a handoff to Judge Turner and then back. So you're familiar with the Intercept model. Certainly last night we heard from Judge Leifman talking about the effort that they undertook in Miami, a 2-day summit in which they performed, in effect, a judicial intercept mapping to identify all of the areas and gaps where there were services in their area. We've had the opportunity to do a similar process in Lubbock County. Today, I'm including the slide primarily to identify the areas we're going to be addressing and talking about, looking at some of the issues in target areas 2 and 3, the initial detention, the initial hearings at magistration, as well as courts. And I want to add, too, is something that I think will become clear with some of my remarks in a moment, is that as we've seen some changes in the law, we really would want a third box here in Texas, where not only do we have the opportunity for a specialty court that you'll hear more about this afternoon, the ultimate dispositional court of the criminal case, but an alternative if we're able to have some kind of diversion with a focus on the possibility of bringing into the picture the court with probate jurisdiction to be able to look at a civil commitment as opposed to proceeding with the criminal process. Let's build on this. I think at this point, you're probably all familiar with Texas Code of Criminal Procedure 1622. This has been a part of the law for close to 30 years. It was first enacted in 1993, became effective in 94, but it was largely dormant. There was not a lot of use of the provision or even broad awareness of the provision, but the legislature, as we know, revitalized it and put greater emphasis in it, starting with the 2017 session, and then there were amendments in the 2019 session. The whole purpose, primary purpose, is to identify individuals who've been arrested, who are at the jail, who have a mental illness, or who have IDD, and to be able to take some steps in that regard once that knowledge is acquired. And so the time periods were sped up. There has to be action taken by the sheriff. In 2019, this was expanded to also include municipal jails. And so jail officials, whether it's the county jail or municipal jail, have to act within 12 hours and get information to the magistrate, for the magistrate then to make an assessment and determine whether there should be a screening interview. And the answer to that question is normally going to be yes, unless, for example, that there's already been such a process that has taken place in the prior 12 months. And so we're familiar with the standardized forms that are used too, that I've got an image of on the screen. A report comes back. And then we start to think about, okay, well, we've got this, but why is the law required? What is it that we want to do with that? And there's several, I think, important aspects to this. One is, gosh, we now have an identification because there's three things that are to be included in this report after the interview. It's a collection of information. Does the person have a mental illness, or is the person IDD? Has there been treatment? Is there recommended treatment? And is this a situation where we might need to tee this up for a later full competency exam or not? Notice the 1622 is taking place early. There might not be charges pending. There's no jurisdiction to order a competency evaluation until charges are pending. Instead, we're looking at this early screening evaluation. And then with the information that we glean, we may be able to identify, okay, well, this defendant's in need of mental health services. If the defendant has not been previously diagnosed, is the defendant willing to take medications? Can those be started immediately at the jail? Because that could go a long ways to obviating the need for future criminal proceedings if services could be started immediately. Obviously, that's not always going to be the case. The person might refuse any kind of mental health care, perhaps because of the symptoms of the illness, but that's one opportunity with respect to the report. The others then look to potentials for diversion. And so I've identified on the slide as opportunities. One of them that is, I think, better known is 17032. That was part of the original legislation in 1993, became effective in 1994, in that the court has the authority to, in effect, let the defendant out of jail on a personal bond with treatment conditions for a wide array of nonviolent offenses. There's a list of offenses that are similar to the old 3G offenses where this isn't an option, but there is this option that's available to try and have this personal bond with the treatment condition. That's going to require cooperation and coordination with the local community mental health authority to be able to provide that opportunity. But the statute authorizes the court to include treatment conditions as part of the order for the personal bond. Newer is legislation that was added in 2019. 1622C5 was additional language added that largely provides a roadmap for a possible diversion, in effect, a possible transfer of the matter out of the criminal court, at least potentially temporarily, and over to the court with probate jurisdiction to look at the possibility of an outpatient civil commitment. We've long had authority set forth in the Health and Safety Code, in the civil commitment statutes, for this possibility of having a civil commitment, whether inpatient or outpatient, when a person is charged with crimes, but the crimes do not involve acts, attempts, or threats of serious bodily injury. This part of 1622C5 is nothing new. That's existed. It still exists in the Health and Safety Code under both the provisions for inpatient commitments as well as for outpatient commitments. However, the legislature found that often courts involved on the criminal side were less familiar with provisions that might show up in the Health and Safety Code. And so the intent with C5 was to spell out in C5 a roadmap for doing just this. So it authorizes the criminal court to, in effect, place the person on bail and transfer the matter to the court with probate jurisdiction to consider then an outpatient civil commitment for the individual. for these nonviolent type offenses. And notice it doesn't draw lines between misdemeanors and felonies. Does the offense for which the charges are pending involve acts, attempts, or threats of serious bodily injury to another person. So that's an opportunity. For this to work, though, it's going to require some cooperation. It's going to require communication between the judges with criminal jurisdiction and the court in the county that has probate jurisdiction. It's going to require cooperation and coordination between the criminal prosecutors and, in effect, the county attorney's office, who would normally handle civil commitments. But coming up with protocols and agreements to try and handle these cases, I think, could go a long ways to be able to use the 1622 information to divert certain nonviolent offenders out of criminal justice and into mental health treatment. Now, if you parse through 1622 on its face, the way I've described it sounds fairly straightforward. I wish that were necessarily the case. Judge Turner, let me kick it to you. Is this as clean and clear a process as it might seem?
As clean as mud, Professor, as clean as mud. I would say that this is a little bit of our segue here. Before we get going, let me just, first of all, I want to express my gratitude to JCMH for inviting me to speak to y'all again. I also particularly want to thank JCMH for teaming me up with Professor Shannon. I told Christy, I said, I am happy to Garfunkel to Professor Shannon's Paul Simon. So, I think that we definitely are talking about a bridge over troubled water here, Professor. I think that, the issues that we're dealing with here are kind of its vantage points. I mean, everyone's in a different situation. I mean, I'm just playing off the cuff here, Brian. But I mean, like right now, you're in a law school making this presentation. You're in an institution of higher education. Meanwhile, I'm here on the second floor of my home, and downstairs, I've got one child engaged in fourth grade at Jocelyn Elementary School virtually, and I got a ninth grader going to school at Austin High School. And it's a very different vantage point. Higher education from the professor's perspective. My idea of higher education is just that I'm on the second floor of my house and hoping that my children aren't going to barge in while this presentation's made. I say all this to you because realistically, we all look at this thing differently. It's not just that law is complicated and that we're prone to have lawyerly disagreements over the meaning of words, but even our idea of how this process looks very substantially. So let me talk to you about this first slide that we have here, what I call illustration A, the ideal. Now, I want to give a big shout out to my colleague, Judge Kirk Noaker. He created this. This is a beautiful chart. I mean, it shows you the way. I call this the ideal. This is the way. This is the way we hope it's going to go. And the only thing I would say to you is, that's the ideal. It's good to study the ideal. But I think particularly now during the pandemic, one of the things that we have all learned is that things are not ideal. Okay. Things are not ideal. And quite often we have to play the cards that we're dealt. That's the reason why I would like to contrast the ideal illustration A with, the not so ideal, which is illustration B. By the way, this is an actual word cloud of the statute. If you want to know which words appear the most, there you have it. So one of the things that I would like to do is I want to challenge each and every one of you to begin thinking about what it's going to take to describe your local 1622 process. And I jokingly ask my friends, I say, are you living your best COVID-19 life? Are you still finding joy? Are you not judging yourself too hard? Are you going with the flow in difficult times? I think there has to be that same spirit of self-forgiveness, if you will, and how we approach the 1622 process. There are acceptable variances. There really is no right way. One of the things that I'm concerned about is quite often I think that when we start having these discussions, you start hearing about how County A does this or County B does this. And of course, you always have the loudest people tend to have, they have the loudest voices. Those are the ones, this must be how it's done. It's simply not like that. there is no right way to do this. I would say there is a wrong way. The wrong way is not trying to make this process work or figure out what the challenges are. You know, there might not be any right way, but in the one pager that I have provided as the course materials, I really tried to strike this note that there are shared challenges that we all face. Some of these challenges are specific to rural settings. Some of these are specific to metropolitan or urban settings. But actually, we kind of have a judo moment here. If we take inventory on what our shared challenges, we have the potential to also recognize some shared solutions. One of the things that the professor stated that I really want to reiterate, because this is me just sharing my own experience with the statute. 1622 is not simple. And you are talking about something that when it became the law back in 1993 only had 521 words. And today it has over 1,700 words. And, you know, I think that a lot of folks think they know 1622, Brian, and they don't. They know it from an earlier point in time. I think that most of the evolution in the statute has occurred in the last two statutes. And so one of the things that I think is really important is that while we know that one, it's not simple, we also know that two, it's not very specific in talking about its implementation. And that's for good reason, because, you know, what's going to work in Austin County is not going to work in Austin, Texas. And what's going to work in Hansford County is not going to work in Harris County, or vice versa. So we really are having an opportunity to kind of stop. And really what I'm asking people to do, what I would ask everyone who's attending the conference to do, is we really need a table reading, Brian. We need people to come and sit down just like they're reading a script. And I know this might sound ridiculous, but honestly, sitting down and reading the statute word for word with people so that you can hear other people's voices and not just your own thoughts is amazingly beneficial. So now that we've said that, let's go ahead and go to the next slide, Brian. I want to talk to you about this kind of what we call 4 C's and 1 wheel. I want to build off of this theme. And you've already heard the professor talk about this, but I want to talk about it kind of in a different light. It really doesn't matter to me if you're living in, if you're in Quanah, Texas, or if you're in Dallas, Texas. There are some universal truths that we're dealing here. And I really want to say this too. We'll talk a little bit more about it maybe on the next slide, but I want to say this now. You're hearing so much about the urban-rural divide, and I think that it has the potential to leave us all feel alienated and demoralized and a little bit dysfunctional, and it does not have to be that way. So let's talk about some universal truths here. When we're approaching this process, our 1622 process, this sequential intercept, the way that you're really going to make this meaningful, the way that you're going to be able to get the most out of 1622 is not just by focusing on the words, but also focusing on the kind of the dynamics between all of the players. And that brings us back to some of the themes that you heard the professor allude to: cooperation, coordination, communication, and collaboration. And as someone who has been a county attorney and who's been a city attorney, look, let's just be honest about this. Governments are not great at working together. I think it's funny when you talk to people who have never worked in government, they talk about the government like it's some monolithic entity. Maybe not so much between the federal and the states, but I think we all know that almost all of us have war stories we could tell about some nightmare about where we were trying to get one county to work with a neighboring county, or even cities within a county to collaborate. I would say that it's important really to, go through this process. And that's kind of where this wheel comes in. This is another great visualization from Judge Noaker that he was kind enough to lend to us in this presentation. Is I would ask each of you to take a look at this wheel and ask yourself, who is really the hub of this wheel? Really having a meaningful 1622 process requires that you take inventory. And it's important that we identify our challenges. And sometimes the biggest challenge is getting people to sit down and have these discussions, trying to get everyone at the table. I think that in my experience, it's true that people quite often use the lack of collaboration or difficulties between certain individuals or entities or agencies. They pretty much use it as a cop-out as to why we shouldn't go forward. It really shouldn't be used that way. You need to really take inventory and figure out the logistics of how this is going to work, because once again, it really is not going to look the same. It's going to look different. The other thing I really ask yourself is, who is the hub of the stakeholder wheel in your locality? I think that a lot of us, it's like, no, after you. No, after you. Well, I would have done something, but I was waiting to hear from them. Well, if they really wanted to do something, they would have called us by now. And that's the reason why I'm stating that trying to build a collaborative model where you focus on these 4 C's is really essential. And let me just say this, that my organization, TMCEC, you'd heard from Judge Hervey yesterday, we're one of the grantees. One of the things that we have focused on is we're trying to focus on partnerships and localities involving cities and counties. And we're trying to focus not just on urban, but we're focusing on urban and rural settings. And so one of the things that we have done is we have hosted sequential intercept mapping conferences to help people work these things out and through a structured method. And so far, we've had a chance to do it in Collin County, Denton County, Tarrant County. We're working on trying to do it with Kirk County. But here's the deal. I feel like I'm saying, if you call in the next 15 minutes, this is what you'll get. Let me go ahead and make a shout out to all of you out there who are watching this presentation today. And I know there are many of you. I particularly am concerned about the lack of partnerships between cities and counties. If you live in a setting where a county and city, if they're all ready to come to table, and you would like to have sequential intercept mapping done, give me a call. I'm looking for cities and counties that are willing to work together to make this 1622 process happen. We're already having preliminary conversations about trying to do this in Kirk County, but I would like to hear from people out there. Once again, I'm looking for partnerships between cities and counties that are going to try to figure out how to make this more meaningful. All right, so speaking of meaningful, let's go to the next slide, Professor. Let's move this one over here. I want to talk to you now about, so that was the 4 C's. Now let's talk about some D's here. We're talking about meaningful collaboration. Let's also talk about, that kind of leads us to discussion of meaningful data. Now, to a certain degree, only thing that Brian and I are doing here in the Brian and Ryan show is we're just foreshadowing things to come. Y'all are going to have a panel discussion about data, but I want to talk to you about data for a second. Meaningful data has been described as the core of a national crisis in criminal justice. And if you take a look at the one pager that I've given you a hyperlink to a fantastic op-ed piece that talks about this. And we really are a nation that seems like we're increasingly obsessed with meaningful data. I was so desperate to find an effective image that I took this screenshot. Actually, Brian, this image about executive decision-making with data science, I took it off my Facebook page because this was an ad I kept seeing over and over and over again. And I don't know if that's supposed to be COVID-19, but it looks like a diagram. It's kind of COVID-y, if you know what I'm saying. And everyone is fascinated of how we can better use data for decision-making. But I want to put a caveat out there. First of all, how people use data is complicated in the sense that how do you capture it? How do you measure it? But quite often, people are just using data to try to substantiate a position that they already assume. They're not approaching this with an open mind, but rather they're just trying to make a point. And that's not really in the spirit of true collaboration and cooperation. The absence of data is a problem. And one of the things, and this is really what I've been telling judges in courts for years, because this is considered one of the court tools for those of you who are familiar with the National Center for State Courts and this focus on court management principles, is that if you don't collect data, if you wait for someone else to collect data, they're going to tell a different story. If there is some story that you want to tell, if there is some point you want to make, you're better off collecting your data and not waiting for a mandate. Because by the time typically someone makes an allegation or makes a statement that you think can't be substantiated by data, you don't have time to collect the data. So data is a complicated thing, and I know you're going to hear more about this afternoon. The other thing I want to talk to you about is this notion of diversion. Diversion is a recurring theme, and we understand that 1622 and 1623, I mean, the focus of these really we're talking about individuals with mental illness or intellectual disability or suffering from mental health crisis. But to have diversion means you really need to have a comprehensive strategy for diversions. And in Texas, to be honest with you, we got a long way to go. One of the things that I have been more than willing to bring to the table and for us to talk about is you can't simply have a top-down approach. You can't simply say you're going to try to divert felonies and not evenly focus on misdemeanors. And by the same token, you can't just focus on misdemeanors and exclude Class C misdemeanors. And so one of the things that Reagan Metallier and I and Beth Rozaki recently wrote about, this is another article I've shared with you in the one pager, and here's an image from the municipal court recorder, is that really you need a continuity of care approach. The fact is, we were told by SAMHSA, they wrote, I think it's been, I don't know, we're getting close to 10 years now. They told us 10 years ago that courts that hear low-level misdemeanors, specifically I'm talking about Class C misdemeanors, Brian, things like disorderly conduct, public intoxication, nuisance offenses, that these are prime opportunities for diversion. And so far in Texas, that's one of those areas that we have not focused much of any interest. I mean, I guess there has been interest, but there hasn't been a lot of focus. That is beginning to change. One of the things that Brian and I were involved in this, I guess it was this last summer. I don't know, Brian. I feel like I have been stuck in 2020 for 5 years. My sense of time is so warped. I don't even know when we worked on the Legislative Research Committee for JCMH, but we do have some very important Class C misdemeanor recommendations that would give much needed guidance to judges and justices of the peace. And the other thing that I think you're going to hear a lot about that we talk about in this article is that the Sandra Bland Act made 1622 an opportunity to identify individuals regardless of what they were arrested for. If they're in distress and they need the 1622 process, it shouldn't matter if the person is arrested for disorderly conduct. It shouldn't matter. If you have been taken into custody and if there is a basis for thinking that we need to use the 1622 process, it should not matter that the reason why the person was arrested is a Class C misdemeanor. So I say all of that to you because we do understand that we have a lot to do, that kind of diversion goes hand in hand and with dismissal. I will tell you that judges always appreciate good, clear guidance. Sometimes the lack of clear guidance is, unfortunately interpreted as meaning that either one, an issue is simply just not that important, or two, that judges are either free to do whatever they want, which I don't think is a good idea, or free to do nothing, even if it's the right moral or legally or constitutionally mandated thing to do. So with that said, I'm going to go ahead and transition it back over so that the professor can talk more with you about the judge's role in these type of mental health cases.
Well, I knew I would do that just because tech is in my employer's name. I have no special skills. So, of course, I blasted away talking with the mute button on. Thanks, Judge Turner. It's always a pleasure to work with you and talk with you. And your comment about your daughter in elementary school at Jocelyn Elementary brought back memories, because I somehow made it through second and third grade there long ago. And it just shows you that school must have been built well, because that was decades ago. Thinking about the judge's role, we keep coming back to this theme, and I love the imagery of the table reading, the summit, bringing people together. As I've shown there in one of the bullets, the power that you have, those of you who are judges, as a convener, should not be underlooked. It is this opportunity to, as some of you have taken advantage of, others certainly have plans in that regard, to bring people together. Judge Leifman, who we heard from last night, we've been fortunate enough to have him come out and speak at Texas Tech in the past. And I remember him sharing a story about how when he first started encountering cases involving persons with mental illness who he was representing as a public defender, he wanted to do something about it. And he wrote a letter to a number of the different offices and departments and police and judges and asked everybody to meet, and nobody showed up. Some years later, when he'd been appointed as a judge, he wrote the exact same letter. Everybody came. It's that authority, it's that gravitas that you have coming from the bench to be able to have these conversations and work through and look at the processes that are there. Obviously, at this front end, prior to the case, it's talked about you're the gatekeeper on some of these diversion options. Got to make determinations under 46B if we're looking at cases covered there by 46B, being aware of those alternatives, and this role to move the docket as well. One of the things that's not necessarily at the front end, but a change from 2019 legislation is the requirement now that when competency has been restored, if that's been a part of the case, and the person comes back from a competency restoration program, whether inpatient, outpatient, or jail-based, that case has to be given priority. You want to move those cases, obviously, while the person is stable and while a medication order may still be in place to have the case resolved where possible. Well, in going further and thinking about some of the additional options and delving in some of the requirements, some of the opportunities and challenges for courts is if we get to competency restoration, if that's something that becomes an issue and an evaluation is ordered, keep in mind that largely you, and in the rare case where a jury is sought, you're making that determination on competency as the judge, as the court. Yes, there's going to be much reliance on the experts' reports, but assure that the experts' qualifications meet the statutory standards and are sound, but also look critically at the reports. A cursory report that doesn't seem to meet the elements of the statute should raise your concerns. Send it back. That's not something that would be consistent with the obligations of the psychiatrist or psychologist doing the report if it doesn't answer the questions or address the topics that the statute requires in terms of having some meat on the bones of those reports to provide you with sufficient information to make your determination. Keep in mind, too, that looking to the competency restoration process as mental health treatment, it's not necessarily one and the same. As those of you in the trenches know, we have long wait lists in Texas. I think the last time that I looked was the end of, it was October 31st or 30th. We had the ballpark of 1,300 people on the forensic wait list in need of competency restoration services. Well, think about that. That's obviously a large number of individuals whom courts have adjudicated them to not be competent to stand trial, and yet there's no program or bed available for those services. And then we're in this holding pattern where the individual remains in custody in the jail during that time. Well, the statutes were changed some years ago. If the person has a mental illness and is in need of medication, that after 72 hours, a medication hearing process can be raised, can be brought for the person who is refusing meds, may not be competent, obviously, to recognize that he or she needs to take meds. That's a process that's available. That's something I think should be looked at critically. What is your process in your county for pursuing that if you've got individuals who remain on wait lists for more than 72 hours? And I suggest you do, given the long list within the state. Also look critically at cases which are nonviolent or misdemeanors. of that 1,300, there's a large percentage of those individuals who aren't competent to proceed, who are charged only with misdemeanors. There's a good chance those individuals are going to time out because the maximum time for which that they could be sentenced or served is going to end up being shorter than the time they're waiting to get into a competency restoration program. Well, that doesn't make good sense. Obviously, constitutionally, somebody can't necessarily face charges if they are incompetent to proceed, but consider other options. Was diversion appropriate? If you're with the district attorney's office and working with defense counsel, is a dismissal a possibility? Now, you still get into questions of competence for being able to plead guilty, but focus could be looked at in terms of some kind of diversion or dismissal. And then 46B, some of the important changes from legislation in 2017 and 2019 is to create a broad framework of options for not just inpatient competency restoration, but also outpatient and jail-based. Dollars were provided to build additional inpatient, and those construction efforts are ongoing. In addition, funding was made available to increase the number of outpatient and create the opportunity for jail-based, but it's still a start. We still have a long ways to go, but it's a good start. I remember probably 10 or 15 years ago, I spoke about these topics to a group of judges, and I remember looking at the evaluations later, and they liked what I had to say, but they thought, gosh, you're just identifying problems. Where are the solutions? What can we do? And there weren't good answers 10 or 15 years ago. Today, that's changed considerably. We've got opportunities now to improve the system in significant ways. And I know it could be slow over the next session to add more programs, given the fiscal restraints that are present because of the state coping with the implications of the pandemic and COVID. But the structure's there for long-term positive changes that are there. And then for the last focus to bring this home, other tips for success, again, taking us back to the table reading and what Judge Turner showed us with the 4 C's and cooperation, coordination is, well, if you're sitting there on the bench, who is your liaison with the local mental health authority and the local intellectual disability authority and vice versa? If your court coordinator is in regular contact with someone or should be, who is it? Can you pick the phone at any time? Schedule that Zoom meeting at any time to discuss the issues. Should there be regular meetings? You bet. And probably quarterly meetings aren't the best approach. It's better than none, but with quarterly meeting, if somebody misses it, then it's a half a year before you get back together. There's a chance to have more regular monthly or otherwise sessions, meetings, and then think through of all the players you want to be at such, not just from the courts, but from the district attorney, county attorney's offices, probation, defense attorneys, the providers, if there are multiple providers besides the local mental health providers. And I recognize in some counties that's more feasible than in others. In the larger counties, you're going to have representatives of certain entities, but is that coordination going on? Are those opportunities there? Because this is a problem that obviously the law by itself is not going to solve. The legislature's done an admirable job of creating new statutory structures. And as Judge Turner mentioned, the commission, we've got a number of recommendations for the next session to try and tweak these laws further. But to make them work and to have opportunities for better outcomes for Texans, that's hard. And it was so encouraging to see the references from Judge Leifman about the things that are possible and knowing some of the exciting programs that are happening in Texas. So let Judge Turner add last thought on that as well.
Well, I just wanted to say this. I got a text message on my phone from one of my classmates who apparently is watching this somewhere. And the text message said that I should confess to you that the 4 C's and the 3 D's are very reminiscent of my first year grades in law school. I don't know why he thought that this was the appropriate time to make that joke. I'm not making any admissions of this sort, but I am going to say this, that I think that if you and I can encourage people to actually sit down and start having these conversations, it's amazing the things that people have been able to learn when they sit down. Because you know who we tend to talk to? We tend to talk to the people we always talk to, okay? County officials talk to county officials, city officials talk to city officials, and that's one of the reasons why the offer is on the table for any of you who want, if people in your local city government and your local county government with your LMHA and other stakeholders are interested in doing with these SIM mappings, give me a phone call. Because I will tell you, Brian, when we did this, one of the first times we did it with folks in Tarrant County. And it was amazing that while everyone had their own little plan and their own little silo, that first of all, most of these people did not know each other. There were tons of people who just simply did not know the other person existed in their community, didn't know what that person's job responsibilities were. And once they began these conversations, not only did it blow up some silos, but it actually kind of illuminated opportunities for collaboration that would have never happened if they had never had the opportunity to sit down with each other in advance. The other thing that I want to talk to y'all about is the way that one of the things I know, there's the state law, that, as we mentioned, it doesn't always, I don't know how many of us really wish that the Code of Criminal Procedure was like IKEA instructions. I'm not sure if I want so much detail or details that are arguably bad and confusing. We know what 1622 requires, or at least we think we do. That's the reason why the table reading is such a good idea. And I'm saying, Brian knows this because as he and I were working together, I was calling him and texting him and saying, oh my gosh, I've read this thing like 100 times. I don't think I ever read this, or I never actually realized that this is what it meant. Approaching the topic with new eyes is really important. And the more people you get that are outside your wheelhouse, the better. I want to remind folks, like I'll give you an example. All of your municipal judges in your locality are magistrates. They're not magistrates for the city. They're magistrates for the county. And we have seen some cities like Travis County has done a very good job of having a partnership with its county, but by the way that they use the municipal judges. But we still have a lot of places in Texas where the counties don't recognize that their municipal judges are magistrates for their county. And so there's never been any impetus or reason to have discussions. And I think that Kirk Noaker does a good job of talking about how much success they've had in Marble Falls. I think that the success they've had in Marble Falls is not unique to that. I just think there are a lot of dormant successes waiting to happen. The other thing that I think that, Brian, you and I have had a chance to see is, remember that this whole JCMH process, it really began with this notion of blowing up silos. I mean, the fact that we had the Texas Court of Criminal Appeals and the Texas Supreme Court, for the first time in the history of our judicial system, convene court together to talk about a challenge. It's not just symbolism. I mean, it shows you that we are dealing with very specific challenges, but the way that we're going to address these challenges is not by doing what we've always done, because, that's how you get what you've always got. We have to do things different. That requires to shake it up a little bit and approaching things in different ways. So, and the other thing, and Brian, you and I have talked about how hard it is in rural Texas. You tend to have people that think that, like, okay, well, Harris County has all these resources, and I live out in a rural county near Lubbock. Well, I can't do what they do in Harris County. So we just can't do it. So we quit. But one of the things you and I had talked about is, the funny thing is that when you talk to the people in Austin and Houston and Bexar County and Dallas County, it's like, man, oh man, there's so many people here. I wish that we could just actually have a simple conversation. Meanwhile, simple conversations absolutely can be had in Wilbarger County. They can be had in Hansford County. They can happen in rural Texas. It's actually easier to get all those stakeholders to the table in rural Texas. So we really need to not just focus on what our challenges might be that could hold us back, but we need to figure out how we can leverage some of the things that we have there that are strategically going in our advantage. Last thing I want to say, these silos that I'm talking about, silo mentality has been written about time and time again. But one of the things is these silos tend to rebuild themselves. So I don't want our people that we're talking to today to think this is a one-time thing, that if you do it once, you never have to do it again. It's like getting, vaccinated when you're a kid. No, this is something that if you do it once and you don't continue to have meaningful conversation, the silos will rebuild themselves. So once again, I'm happy to be the cheerleader or the pep squad leader for every rural and urban county out there that's wanting to blow up silos, because ultimately that is going to be how we're able to make the 1622 process more meaningful as we move forward. Brian, anything else? I don't think we have to sing. We said if we had to, we would do that.
Yeah, I'm still nervous about the Simon versus Garfunkel that you were gonna.
I told Christy, she told me who she wanted to part me with. I said, I will Garfunkel for the professor anytime. It's always a pleasure to work with you, sir.
Yeah, absolutely, Judge Turner and Dr. Martinez. We'll kick it back to you. I see the signs up for our time, but we really appreciate the chance to be with everybody today. So thank you.